Good afternoon. It's great to be back with all of you. April 18th here in New York City. It's a bit overcast. We're definitely in that in-between period where we have 1 foot in spring and we're heading towards summer. And it's great to be here for what is a very full program. And let me get to the outline with all of you of what we're going to cover. If Kate, you'd advance to the next slide, please. I'll walk you through the goals for the 45 minutes we have together. And again, thank you as always for being with us. So I will start with some introductions, generally of what we're up to for today. And I'll briefly touch on what's going on with the budget. We're getting close. That's the headline. And then Teresa Schoeneck is back. Teresa will be speaking about model sexual harassment prevention policy templates that New York State has released. Allison Contreras, new to the program, will be talking about ChatGPT and other AI. It's a hot topic right now, and we want to give you some sense of where it might fit in terms of your work with Bond and things you should be thinking about. John Sweeney, who is down the hall from me here in New York City, fairly new to our Bond team, but very experienced in workers' compensation, among other areas of the law, will be speaking about the high points of workers' compensation. So all of you have an awareness of that a little bit more deeply than perhaps you would otherwise have, because John really knows the space. Jared Joyce is back out of our Syracuse office, and he'll be touching on CHIPS Act proposed rules that I think are going to be worth a listen. And then I will, as we have time, just quickly touch on the healthcare worker bonus program, a favorite we've all spent some time discussing in the past. There are some new contours that are worth at least just quickly highlighting for you. And we'll be done by about 12:45. So next slide, please, if you would. Thank you so much, Kate. And so, as I mentioned, we are close on the budget. There is a sense that it could be just a matter of days. I checked just before coming online, and there's nothing published that the agreement has been reached, but it's very, very close from all signals. And bail reform was the big sticking point, as most of you are familiar. And what evidently is the compromise position is that judges will receive some discretion that the governor was hoping to ensure was built into the budget language around violent felonies and usage of bail in those circumstances. But bail's definition more generally will remain pretty narrowly defined as a means of ensuring someone returns to court as opposed to other punitive components that were part of some of the preceding reforms. I mentioned as well that we're super close on getting a budget. There's extender language that gives until Thursday to get it done. It's unlikely that more would be needed. We also are seeing in the proverbial other news up in Albany that the Honorable Rowan Wilson has cleared committee and is expected next to receive full Senate approval to be New York's next chief judge. This has been, of course, a contested position. The previous nominee by the governor, Hector LaSalle, was ultimately not confirmed. And so this is looking to be much smoother sailing. Why don't we go to the next slide, please? And with that, I will bring Teresa forward. Teresa, thank you again for being back. Teresa has been watching the issues around harassment prevention very closely on behalf of all of you, has done a lot of writing on it as well, has come onto the program to speak about it before. And there's a new wrinkle. Model policy language has been released. As a reminder, Teresa is an associate based both in Rochester and Syracuse with deep experience in employment and labor matters generally. Teresa has been on this program a number of times before. I'm confident she's familiar to you. And Teresa, I'm looking forward to learning. Please go ahead, and thank you for taking the time to be with us.
Thanks, Gabe, and hello, everyone. Thanks for being with us. So, as Gabe mentioned, we have a new model sexual harassment prevention policy. If you could go to the next slide, Kate. All right, so You may recall back in January, I appeared on this program and talked about the proposed policy that had been released on January 12th, and it followed the model policy that we had had in place in New York since 2018. On January 12th, we got notice from the state that they were looking to revise that policy, which is part of their state mandate. They have to do it every 4 years, or at least look at doing it every 4 years. And it was last done in 2018, and that's kind of the policy we've had here on out. So in January 12th, they released their proposed changes to the model policy. They had a notice and comment period for a couple of weeks that closed on February 11th. And then on April 11th, just about 2 months later, we got the final model policy. And as a bonus, we got an updated model training as well. So although the state had not released a proposed revised training, they ended up giving us a revised training anyway when they came out with the policy. So that all happened last week, a week ago today. The revised policy is 11 pages long. The former policy was 7 pages, so they've added quite a bit of content. And the former training video was 2 videos. The revised training is 1 video, and that's about 10 to 15 minutes longer in total amount of content as well. So next slide, please. So there's a number of changes between the revised policy and the model policy that we had been using since 2018. I'm not going to get a chance to go through them all today. One of the biggest changes that we saw was this emphasis throughout the policy on gender diversity, and particularly on how harassment on the basis of gender is a type of sexual harassment. So the policy includes now definitions for terms like cisgender, transgender, and non-binary persons. It includes additional examples of gender stereotyping, such as remarks regarding someone's gender expression, wearing a garment typically associated with a different gender identity, asking employees to take on traditionally gendered roles, such as asking a woman to serve refreshments when it's not part of or appropriate to her job, intentional misuse of an individual's preferred pronouns. All those are new examples of sex stereotyping and gender stereotyping that New York State has included in its revised final policy. Next slide, please. We also see a whole new section in the policy on bystander intervention, which encourages bystanders to report harassment, and of course mandates that supervisors who are bystanders report harassment. The policy also provides 5 specific methods for intervention. One of them encourages employees to record sexual harassment as it occurs, which I think could be ultimately problematic for some employers. But certainly there's a whole new section on bystander intervention in the revised policy. There are also new sections throughout on remote workers, including things such as remote workers can be harassed over virtual platforms and messaging apps. Certainly harassment can also occur between personal cell phones. And then there's also a section on how posters and other content in the background of virtual platforms can be harassing. Next slide, please. There is a new sexual harassment prevention hotline that actually came out this past July, but this has been included in the policy for the first time with the revision of the model policy. This provides employees or individuals who believe they have a sexual harassment claim or have sexual harassment concerns the ability to call a free hotline and speak with a volunteer attorney who can provide limited free assistance and counsel over the phone. We're going to talk a lot about what needs to be in your policy versus what you can put in your policy. And I'll highlight this specific hotline because this is something that has to be in the policy. When the hotline came out, it was a separate piece of legislation. And as a part of that legislation, the state said you have to include this hotline information in your policies. So even if you end up not changing your policy so much, you definitely want to make sure that hotline information is in there. And I suggest using the language in your policy that New York State uses in theirs, which is the language that's quoted on this slide. The revised policy also has additional examples of retaliation, some of which I think are more problematic than others, such as saying it's a retaliatory move to bring an employee to a less desirable office and make that their new working location, things like that I think could be a little more questionable for some employers. And then there's this larger question. I already got it in the Q&A I saw before I even started talking about whether the revised policy needs to be adopted. And I think this goes for the training as well. Generally speaking, even back in 2018, employers weren't required to adopt New York State's model policy, either in part or in full. What they were required to do is meet minimum standards set forth by the Department of Labor. Those minimum standards have not really changed since 2018. And so these changes to the policy, you could make the argument, do not have to be adopted. I think there's a little play in the joints there because one of the minimum standards says you have to adopt a policy consistent with guidance from the Department of Labor. And this policy is, quote unquote, the guidance from the Department of Labor in some respects, but you certainly don't need to adopt the entire model policy. You just need to make sure that your policy, whatever it is consistent with the minimum standards set forth by the state, and that it doesn't conflict with anything in the model policy as it has now been revised. So next slide, please. Okay, quickly on the revised training. The former training was 2 videos, 19 minutes of instructive lecture, 22 minutes of case studies. The new training is 54 minutes, so it's a bit longer. It mirrors the changes found in the policy, so things like gender diversity, additional examples of retaliation, remote workers, all of that's now in the training. It also includes a forum for employees to answer questions about the case studies, which I think is really important because, as you may recall, the training has an annual component to it. You have to give the training once a year and you have to distribute your policy once a year too. But the training also has to be interactive, which means just showing your employees a video, even if it's the video from the state, wasn't going to cut it. You had to have some way to make that training interactive. And for the first time, the state has released a form that allows employers to do that by giving it to their employees and having them answer the questions about the case studies. So I think that's interesting. Obviously, there's other ways to make your training interactive as well. So I know this is a very brief overview. Like I said, we have over 3 pages of additional content, and I know there's going to be other questions about whether or not this needs to be adopted in full or in part, and which parts should you put in and not put in. So we have an upcoming webinar on the 27th from 8:30 to 9:15 in the morning. I'll be presenting with my colleague, Kristen Smith. You can sign up for the webinar there, and I believe invitations were also mailed this morning. So if you have more questions about this topic, please tune into the webinar or feel free to reach out to me or any other bond attorney. We're happy to help.
Teresa, thank you. That was terrific. And I encourage all of you who are looking to dive in more deeply on this topic to find that time on the 27th. I know that you'll all learn a whole lot more. And Teresa, if you have a chance, there are a variety of questions in the chat that came in, some of which perhaps you can answer today and others that you'll get to on the 27th. But for now, let me say thanks and welcome our next speaker, who is Allison Contreras, who is with us from our Buffalo office. And Allison is here to introduce a topic. This won't be the last time we're talking about it. It's arguably a massive one. It's artificial intelligence and the way it's changing so many of the ways in which we do business, both in the legal profession as well as there are many others that are certainly ultimately going to be touched by it. But today we're not going to be talking about, essentially where we are in 5 years. We want to talk about where we are today, what we know, and some of the issues that we think all of you should be considering, and perhaps turning to us to better understand. And so, Allison, please begin that outlining for us, if you would. And thank you so much for joining the program from Buffalo. We're really glad to have you here.
Well, thank you, Gabe. And hello, everyone. I'm Allison Contreras. So today I'm going to discuss ChatGPT and some of the concerns associated with using ChatGPT. So to start, ChatGPT is a natural language processing tool driven by artificial intelligence technology. It's designed to provide human-like conversation experiences by providing natural language and generating responses. ChatGPT was developed by OpenAI and released in November 2022. It is a web-based platform, which means users can access the site like any other website on the internet. Now, if you're unfamiliar with ChatGPT, you may be wondering, well, how does this work? As a language model, ChatGPT requires large amounts of data to function and improve. ChatGPT relies on a dialogue format, which means users can interact directly with the chatbot using typed commands or questions. The model is trained to follow instruction in a text-based prompt and uses deep learning algorithms to develop human-like responses. Essentially, the more data that the model is trained on, the better the data or the model gets at detecting patterns, anticipating what will come next, and generating more plausible text responses. Next slide, please. What are the capabilities of ChatGPT? Well, ChatGPT has many capabilities because it can generate text in a variety of styles and tones. For instance, ChatGPT can answer questions, assist with various tasks like composing emails, articles, essays, writing music, or developing code. Additionally, ChatGPT can facilitate communication, assist with language translation, explain concepts, and generate ideas. ChatGPT can assist in language learning by generating examples and conversational scenarios that can assist individuals with practicing and improving their language skills. Lastly, ChatGPT has the ability to retain what users said in earlier conversations, which allows users to provide follow-up corrections or build off previous generated responses. Altogether, these capabilities can enhance efficiency, improve language skills, as well as accessibility for individuals with disabilities. However, there are concerns associated with using this technology. Next slide, please. For starters, there's concerns about accuracy, transparency, and reliability. First, the content on ChatGPT is not current and up to date. It is only current through September 2021, which means that ChatGPT has limited knowledge of the world and events after September 2021. This is likely due to the fact that the technology needs to be trained to learn. So from the point that it's trained up to, it can provide responses, but anything beyond the training point, it will not retain information or provide responses accurately. There's also a concern about lack of transparency. Users do not know where information is coming from because ChatGPT draws on vast pools of online content to stitch together plausible sounding responses to almost any question it encounters. So without knowing where the information is coming from, responses may be unreliable and users may find it difficult to identify and correct errors in the response or to even understand how ChatGPT arrived at a particular output. Another issue users are facing is that any of the outputs could be inadvertently plagiarizing. Developers say that the model does not intend to plagiarize any text, but it does have the potential to produce a response that is closely similar to another source out there. So essentially, if the model was trained with proprietary or copyrighted information, there is potential that responses will be generated by the chatbot using these copyrighted or proprietary pieces of information without the user even knowing. One of the biggest limitations of this technology is its ability to lie so convincingly. This is because the model is trained to produce text that is plausible, not text that is factual. So this leads to ChatGPT generating convincing but fake text responses based on the information it was trained on, which leads us to a concern about the information the bot has. The model is only as good as the data that it is trained on. So if the data source is biased, then ChatGPT may amplify those biases by generating inappropriate, offensive, false, or misleading content, which leads us to a concern about the spread of misinformation. There's been users that have reported that ChatGPT has completely made up lies about them. One example is ChatGPT making up a sexual harassment scandal and naming a real law professor as one of the accused. Now, this was found by a colleague of this professor conducting research using ChatGPT. She asked ChatGPT to generate a list of professors who had sexually harassed someone. And the chatbot generated a list, but identified someone who had not had any allegations against him. It also went further to state plausible facts to back up whatever allegation it made up about him, and also cited to a Washington Post article that did not exist. So not only did the model misrepresent key facts, but it also fabricated primary sources to back up these false claims. Another example involved an Australian mayor who was known as a whistleblower that helped expose a worldwide bribery scandal in Australia. However, when you ask ChatGPT, he was actually a convicted felon he was convicted of paying bribes to foreign officials. He had pleaded guilty to bribery and corruption and had also been sentenced to prison. None of this was true. Apparently, the machine completely fabricated everything from scratch and made this information and started distributing this misinformation, which leads us to concern of privacy. So there is data collection and retention concerns because OpenAI's privacy policy allows for users' information to be collected and shared with unspecified third parties. Some of the information they collect are users' IP addresses, browser type and settings, users' interaction with the site, which includes the type of content users engaged with, the features that they used, actions users took. All of this information is fed into ChatGPT with little control over how it is used or how it is shared. Data provided to ChatGPT and user prompts, along with the responses from the chatbots, are also used to further train the model and also then used to respond to other users' prompts. So whatever information you input into the model will be stored and used to train the model further, which involves privacy and the spread of misinformation. Next, there's cybersecurity concerns. There's the potential for the model to be manipulated and used for malicious activity, such as phishing or developing malware. This program can allow for cyber criminals to become more efficient and even more convincing because the content will be more realistic and it may eliminate language barriers or identifiable errors in the phishing email that is generated. There's also communication challenges with this program because ChatGPT is not human. It lacks emotion and experience. It also has trouble understanding certain commands when stated a certain way, and the quality of responses sometimes lack reasoning or make no practical sense. Next slide, please. So looking to the future, this technology will continue to develop and become more advanced. It's important to stay cyber safe and aware of what information we're sharing and uploading online. It's recommended that you don't share or upload confidential information to ChatGPT because of those privacy concerns that I previously discussed about ChatGPT collecting and retaining users' information. So be mindful of what you're inputting into this technology. Next, it's important to be mindful of how not only you are managing your organization's data, but how third-party vendors may be handling your data. This would be a great time to speak with a bond attorney about how to take steps to protect your data in contracts with third-party vendors. It's also important to remember that ChatGPT is a helpful tool or resource, but not a replacement to critical thinking and reasoning. Bond will continue to monitor key developments in generative artificial intelligence technology, as well as proposed legal framework governing AI, and we will keep you up to date on any sort of developments. Right now, I'm closely monitoring a blueprint for AI Bill of Rights. And with that, back to you, Gabe. I will open it up for questions.
Well, that is really informative and certainly important for us to continue to come back to all of you about. And so know that Allison is presenting on this topic for the first time, but we do expect to provide you updates on AI. It's worth noting that just over the weekend, the CEO of Google was on 60 Minutes talking about AI and calling for regulation in the space, just to try to bring some order and accountability. So a lot more to unpack here is the point. And Allison, we're really glad that you took the time to start that conversation with this group. And please come on back to a future program. And with that, let me bring on our next speaker, please. And so we have John Sweeney with us. John is down the hall from me here in New York City, in Manhattan. John is someone who knows workers' compensation law backward and forwards in a way that is certainly differential, and we're grateful that he's here to tell us a bit about what are some of the key elements in workers' comp law that are relevant for employers. For all of you who are interested in knowing a little bit more about John, he comes with really steep background, both working in government and in related spaces. And He's brought that experience with him to Bond. And John, I'm looking forward to hearing more about the kinds of connections you see for Bond's clients with regard to your work. Please go ahead, and thank you so much for taking this time.
Thank you, Gabe, and good afternoon, everyone. I just joined the firm a few months ago, and prior to that, I'd spent the last 30 or so years working for large employers in New York. I managed the workers' compensation program for New York City employees for a long time, and then after that, I spent 3 years managing the New York City Transit Authority's workers' compensation program. And during that period, I also I edited a treatise on workers' compensation in New York for the New York State Bar Association. So I'd like to just talk about a few areas where you might run into workers' compensation issues, even though you don't see them every day. Let's just starting at the basics. Workers' compensation law in New York is a no-fault statute that provides two things. It provides partial wage replacement, and it provides medical treatment for people who are injured in the course of their employment. The workers' compensation law applies to almost all employers in the state and to almost all employees, be they part-time or full-time. The workers' compensation law is administered by the New York State Workers' Compensation Board. And they issue determinations regarding what issues that arise in workers' compensation. So the first thing to be aware of is that as an employer, you need to provide for workers' compensation benefits. And there are two ways you can do that. One is to qualify as a self-insurer and pay those benefits directly. And the other is to obtain insurance and have your insurer and their administrator handle the claims for you. The Workers' Compensation Board is funded by contributions from all employers in the state. So if you're a self-insured employer, you pay your assessment to the Workers' Compensation Board directly. And if you have insurance, your assessment is included in the money you pay for your insurance premium. Now, the Workers' Compensation Board is made up of 12 commissioners. They're appointed by the governor, and there is a chair as well. Those people are responsible for all decisions regarding workers' compensation. And they delegate a lot of those decisions in the first instance to administrative law judges. There are approximately 100 or administrative law judges throughout the state of New York. And the way it works is if there's an issue arises in a workers' compensation case that needs a determination, a dispute, say, the parties go before a workers' compensation judge. The workers' compensation judge makes a determination on whatever that issue is. And then if a party is dissatisfied with that determination, they have a right to appeal that. You appeal it to a panel of 3 of the commissioners of the Workers' Compensation Board. And then they will issue a decision which will either affirm the lower decision or reverse it or modify it in some way. And that's typically the end of the line for a workers' compensation issue. It's possible for certain cases to go to the courts, but very few cases actually do. Normally, the Workers' Compensation Board decision is the last thing that happens in a case. So, as I mentioned before, you do need to be aware of having insurance or to qualify as a self-insurer, and that's important because there are penalties if you don't do that. The board can impose fines on an employer who fails to have insurance in place, and those fines they can grow day by day, and they can be pretty hefty. And certain individuals could also be prosecuted criminally for failing to have workers' compensation insurance available to their employees. The next area that you might run into workers' compensation in as an employer is in personnel issues. The workers' compensation law, the goal is that people not be discouraged from claiming workers' compensation benefits if they're entitled to them. And so there's a provision in the law that's referred to as the discrimination provision. And that what that means is that you cannot take adverse action against an employee who has claimed workers' compensation benefits. It doesn't mean you can't, engage in personnel activity. You just cannot predicate your decision based on whether or not somebody has made a claim for workers' compensation. So, for example, as you know, you may have instances where you have a job transfer for an employee, where you have some disciplinary action, or you're making a decision to terminate that employee. In all those contexts, you want to be aware of whether or not the employee has claimed workers' compensation benefits or is about to claim workers' compensation benefits. Because if you take that action, if it appears, if the workers' compensation board concludes ultimately that you took that adverse action because of the workers' compensation case, you can be held liable for damages. In a typical case, what would happen is, if, let's say, an employee is terminated because they haven't been out in work for a while, and then they claim it was because they're out on workers' compensation. Well, you can terminate employees who were not able to do their job, but you can't do it for workers' compensation alone. So if let's say you have a rule that people who don't come to work for 6 months will be terminated, that's okay as long as that applies to everybody and doesn't apply just to workers' compensation claimants. If a claimant files a discrimination claim and the employer gets an adverse decision, the employer can be required to reinstate the employee or put them back in the position they would have been before the adverse decision. Can also be liable for back pay and fines. So it's something you really want to be aware of when you're engaging in various kinds of disciplinary or even just personnel actions such as transfers. And another third area where you might run into workers' compensation issues has to do with lawsuits. One of the features of the workers' compensation law is that an employee who gets workers' compensation benefits cannot sue their employer for negligence in causing the injury. So what sometimes happens is the employee can sue a third party, though. They can, let's say the employee works with a piece of machinery and they get hurt. Well, they can sue the third party for negligence because the machinery was designed poorly, but they cannot sue their employer. Now, there is a wrinkle to that in certain cases, the employee sues defendant number one, who then claims that the employer is responsible. Most of the time, the employer cannot get dragged into the case, but there are certain exceptions. There's something called a grave injury, which is a very limited number of cases, and it involves very severe injuries. It applies to death claims and catastrophic injuries. It doesn't come up all that often, but that's one instance where the exclusivity provision of the workers' compensation law does not apply. If it does apply, if you're handling a workers' compensation claim for an employee, one of the first questions first you want to get legal counsel on how to handle the claim. But secondly, what you want to do is take a look and see, do we have a defense here? Because if an employee tries to sue and they're entitled to workers' compensation benefits, that case can be ultimately dismissed very quickly without having to go through an entire trial. So those are just some of the areas which I think you'll see workers' compensation benefits issues pop up. And I would ask you that if you do have workers' compensation questions or issues, please feel free to reach out to me with any of those questions. I'd be happy to discuss things with you.
John, thank you so much for taking the time to allow our audience better understand the experience that you bring to Bond and to work through some of the elements in workers' compensation that you have gotten to know over the course of your career through the various different and significant stops you mentioned before joining us here. And so with that, let me encourage the audience to reach out to John as John encouraged, and then B, turn to our next speaker, please. And that will be Jared Joyce, who is with us from Syracuse. Jared is back on the program here to talk about the CHIPS Act. Jared has talked about issues around technology before, and we're really glad to have Jared on the program again. So Jared, thank you for catching us up. We look forward to learning through the presentation you'll be delivering in just a moment.
Thanks, Gabe, and thanks everybody for joining us. So last month, the Department of Commerce released a notice of proposed rulemaking and request for public comment detailing their plan for national security guardrails that are aimed at preventing CHIPS funding from being used by adversaries to the US or our allies. The proposed rule provides additional details and definitions for the guardrails that were included in the CHIPS and Science Act. The first of which it establishes standards that restrict the expansion of advanced manufacturing in foreign countries of concern. Those are primarily Russia, Iran, North Korea, and China. And the proposed rule prohibits recipients from participating in significant transactions that involve the material expansion of leading edge and advanced manufacturing facilities in these foreign countries for a period of 10 years from the date in which they received their CHIPS Act funding. The proposed rule defines a significant transaction as a transaction in excess of $100,000 that results in a material expansion of 5% or greater of an increase in the manufacturer's existing capacity. The proposed rule also limits the expansion of legacy facilities in those foreign countries of concern. Legacy facilities, which are already in operation and produce older chip models, are also limited under the rule. The proposed rule limits funding recipients from adding production lines or expanding a legacy facility's production capacity beyond 10%. It does allow for the construction of new legacy facilities, which would be producing those old chips, so long as 85% of the facility's output is incorporated into products that are going to be consumed within the country that the chips are made. The proposed rule also requires notice be made to the Department of State prior to the expansion or construction of any legacy facility. The proposed rule details restrictions on joint research and licensing with foreign entities of concern. Foreign entities of concern is broader than the foreign countries of concern. It includes people who might be on the BIS list, who are limited with trading with. The proposed rule defines a joint research effort as any research and development undertaken by two or more persons, in technology licensing as an agreement to make patents, trade secrets, or know-how available to another party. As I said, the proposed rule also expands on the definition of foreign entities of concern. The proposed rule also classifies certain semiconductors as being critical to national security. And as I said, the proposed rule allows for the expansion of legacy chip production. It also creates a distinction between certain types of these legacy chips, classifying some of them as critical to national security, which subjects their production to additional requirements. The chips that receive special national security classification tend to be those used in quantum computing, high radiation environments, and in other military capabilities. And lastly, it reinforces U.S. export controls. The proposed rule reinforces prior export controls on semiconductors created by the Bureau of Industry and Security to prevent the People's Republic of China from purchasing chips that could be used to enhance their military capabilities. The proposed rule aligns the thresholds and prohibited technology between export controls and the CHIPS national security guardrails. Oh, I'm sorry, I was supposed to ask to advance to the next slide. And lastly, the comment period on the proposed rulemaking ends May 22nd of this year. Thank you.
Well, thank you, Jared. And while this topic is one that some of you may be learning about for the first time or otherwise have lesser background, and just for all of you to appreciate, there is a complicated world around how we in the United States protect our technology and our technological developments, including through the federal statutory and regulatory schema that Jared was describing. And we know that here at Bond, we serve some of you who interface with that world in terms of the products you develop and otherwise bring to market. So bring your questions, please, to Jared and others on the team who have experience that can be of value to you. And Jared, thank you for coming on the program to bring us all up to speed on what's new there. And with that, let me run through in the time that we have remaining a brief update or two. And if you advance to the next slide, please, I'd appreciate it. Thank you, Kate. The Healthcare Worker Bonus Program is something that I've presented on to this group before. It touches a wide array of providers, not just those squarely in healthcare, but those in education and in other settings. This was a program that came out of last year's budget. About a year ago was approved, and implementation began in August of last year. And we're now in the third vesting period of what will be 5 vesting periods. As a reminder, individuals who are eligible as employees to receive funding through this program can get up to $3,000 divided over 2 vesting periods. So enough background on that, but for all of you who have been working through as employers, your obligations under this program, we know that's many of you. The third vesting period, again, as I noted, is presently live in terms of the reporting opportunity through the portal that New York State set up. And the headline here is that essentially New York State has made it clear that for anything that transpired, broadly stated anyway, in the first and second vesting period that needs to be cleaned up just because the program rolled out in ways that took time, both from the state's operational perspective and otherwise as questions that arose were answered. This is the chance you can go back into the portal and make adjustments, make corrections, etc. And as we also brought forward to you, there was at the end of last year an expansion of the program. So some employers and employees who weren't previously part of the program now are. If you have questions in any respect about how to report, what your obligations may or may not be, certainly I'm a good resource for that. There are several other attorneys at Bond who are also closely involved with guiding clients on this program. So please do reach out, but really what we wanted to make sure you had in mind was that this vesting period is one really intended from the state's perspective as a chance to look back and to go and ensure that anyone who hasn't been properly captured from an employee perspective in the program is now ultimately, or their status is ultimately resolved. So reach out again offline, and I'm happy to be of help, as are several other colleagues of mine I can put you in touch with. Why don't we go to the next slide, please, if you would. And so, Kate, thank you. I just wanted to remind all of you about our annual Labor and Employment and Human Resource Conference. We were delighted that we were able to bring that live to you last year after a COVID pause, and we're live again. These opportunities are upcoming across the state where Bond has its offices and where all of you do your work. We're really excited to be available to you. Colleagues from the team will be in these various settings to present to you on all you need to know as leaders of workplaces. And so we thank you very much for heading on to our website, bsk.com/events. If you're looking for more information as well to register. And that brings us to the end of our program for today, April 18th. We're just, more than anything delighted that you continue to tune in and to learn from all of us. We know that we won't be able to answer all your questions in our presentations, so you have our email addresses on the slide there in front of you if you do have questions. Kristen Smith will be with you hosting next week, and I should be back with you in 2 weeks' time. In the interim, wishing all of you a terrific afternoon, and we thank you for your loyalty to the program. Be well, be safe.